Arbitration is usually more expedient, and depending upon the amount of dispute, arbitration can be less costly. The costs to file for an arbitration are more costly than district court usually, but the attorney's fees, because you can get it done faster, sometimes arbitration is a little bit better. Depending on the rules in arbitration, if any evidence may be allowed. The nice thing about arbitration, as long as you have you can actually put in the contract how arbitration is going to occur. You can put in the discovery rules, and discovery rules essentially are questions that you can ask the other side, whether it be in a deposition, which is kind of a question and answer session, or whether it's formal discovery, which is you send out written questions to them and ask for written documentation to come back. Those are things that you can actually address in your contract if that's what you want to be allowed. And you can also say how the arbitrator is to be picked. The nice thing, if you're writing the contract, and if you have the leverage, you can say that you get to pick the arbitrator, you get to pick where it's going to be held, and you get to pick the time frame. Kind of a nice thing when you are the person that has the leverage in entering the agreement. It's not a public hearing, so there's no public record of the proceedings, which is sometimes nice. And the arbitration process can be less adversarial. So if you have a business partner or a business that you do business with frequently, but there may be some disputes that may occur in some of the technical terms of a contract, arbitration may be prudent from the perspective to maintain that business relationship because, again, it's less adversarial. Okay? And arbitration is much more formal in litigation. However, usually there's no or very limited ability to appeal the decision of an arbitrator. Most of the time, an arbitrator's decision is final. And arbitrators really can make their decisions for whatever reasons they want. And sometimes they split the baby, and sometimes they don't do a good job sometimes. And choices of arbitrators are usually limited and can be a gamble. And again, there's usually limited ability to conduct discovery, and again, it depends upon what you put in your contract. Any questions on arbitration versus litigation?